Welcome to Enlightened Despot, Episode 5. I'm a lawyer, trained in both common law and French civil law. I thought I would try to share with you my thoughts on a legal concept that may be of some importance in these times, called the rule of law, and perhaps help you understand what it is. And I think a lot of people need to understand what it is. That the law in a highly politicized environment is not going to save you, at least not consistently. In fact, it will probably do the opposite. I don't blame people for this misconception. You've been lied to probably your whole lives about what the law is, and especially what constitutional law is. People literally think all their rights are written down there. And what courts do is they open a book, look into these documents, and discover those rights. I'm afraid it is a little bit more complicated than that. So what is a Bill of Rights? What is a Charter of Rights? And how do they work? Lawyers and judges are not going out of their way to tell you what is going on. So I'm not surprised when I hear people, even in the middle of government overreach like we're going through right now, when I hear people say, "We're not worried. The government has no power to do what it's doing. It has no power to do this or that. I know better. We do not consent." There is a lot of this kind of attitude in dissident circles in particular. There's a lot of this kind of language going on in places like Canada. They are, I suggest, getting a lot of misinformation from certain people who simply do not understand the legal system and how it works. Even in a society that has been governed, for the most part, by democratic institutions, and I'll put that in quotes, democratic, close quotes, institutions, and in societies governed by, again, in quotes, the rule of law, close quotes, even in these types of societies, people really think they can just not consent and the government will go away. So let's just get this straight. Governments are immensely powerful. They've probably never been more powerful. And if you've read thinkers like Juvenal, you might notice historically the French king before the revolution was nowhere near as powerful as the state after the revolution. And I'm talking about the French Revolution. The Russian state was nowhere near as powerful as the Russian state after the Bolshevik Revolution, and it goes on and on. We are in the midst of this type of change, and believe me, the government is powerful. Even more so when it is exercising powers under a permanent state of emergency. Our governments, you could say, are all powerful, and in a secular materialist world, they may, in fact, even be almighty. Be careful what you do and who you listen to. This is a super big topic. So let me just try to focus and start with some basics. What is the rule of law? When considering what this means, ask yourself, why do courts come down with the decisions they do? Why do they come down with decisions that seem contrary to all the facts, as you know them and understand them? Why do we see decisions that are surprising, incomprehensible, gee whiz, political, Why are other decisions very sensible and predictable? What's the difference? To answer these type of questions, you really need to be asking, is a particular issue that comes before the court political or not? As Aristotle said, man is a political animal. Women may even be more political. Judges are, for the most part, men and women. Today, judges are quite literally trained in politically acceptable ideas. This is especially true of younger judges. If they don't check the right boxes politically, they do not get appointed. Of course, this would have been as true in 1066, 1866, or 1966. It's just that the regimes are different. Robin Hood is not going to be called to the bench in 1066, and Karl Marx is not going to be called to the bench in 1866. If a judge is elected, he or she is inherently political, as is actually the case in many U.S. states, I understand. If a judge is elected, is there any question decisions are going to be influenced by politics? How could it not be? How could they not be? If there are rioters outside the courtroom, do you think a judge or jury is going to be worried about, I guess we could say, their careers, their property, their families, whether they might get tossed out of the golf or yacht club? I think so. Okay, so what is the rule of law supposed to be? And I'm just looking at some quotes from the Oxford English Dictionary. The rule of law is defined as, in quotes, the authority and influence of law in society, especially when viewed as a constraint on individual and institutional behavior. Hence, the principle whereby all members of a society, including those in government, are considered equally subject to publicly disclosed legal codes and processes. The term rule of law is closely related to constitutionalism and refers to a political situation, not to any specific legal rule. Use of the phrase can be traced to 16th century Britain. In the following century, the Scottish theologian Samuel Rutherford employed it in arguing against the divine right of kings. John Locke wrote that freedom in society means being subject only to laws made by a legislature that apply to everyone, with a person being otherwise free from both governmental and private restrictions upon liberty. The rule of law was further popularized in the 19th century by British jurist A.V. Dicey. However, the principle, if not the phrase itself, was recognized by ancient thinkers. Aristotle wrote, "It is more proper that law should govern than any one of the citizens." The rule of law implies that every person is subject to the law, including people who are lawmakers, law enforcement officials, and judges. In this sense, it stands in contrast to tyranny or oligarchy, where the rulers are held above the law. Lack of the rule of law can be found in both democracies and monarchies. When there is neglect or ignorance of the law, the rule of law is more apt to decay. It's also more apt to decay if a government has insufficient corrective mechanisms for restoring it. Additionally, this will allow for the breeding of corruption, making it even more difficult to restore it as time goes on and corruption embeds itself deeper into the governmental systems. But something is missing here, something more basic. I practiced law for 27 years. Who knows, I may practice a few years longer. Years ago, I turned my mind to linguistics and the law, and I'm sure I have my paper on that somewhere. What I would add to the theory, as I've read it out there, is that the rule of law, or simply law, at its most basic functional level, is the rule of words, that words can control people, that they have content. I think this comes across more specifically in the definition of the rule of law set out in the Black's Law Dictionary. I'll read this one. The rule of law is a legal principle of general application sanctioned by the recognition of authorities and usually expressed in the form of a maxim or logical proposition called a rule. Because in doubtful or unforeseen cases it is a guide or norm for their decision. The rule of law, sometimes called the supremacy of law, provides that decisions should be made by the application of known principles or laws without the intervention of discretion in their application. An example: if I say masks are mandatory when entering this building or a building, well, we have to be able to agree on what a mask is, don't we? A mask is not an octopus. Unless maybe you're thinking of Alien 1. But could a mask be a Halloween mask? Or must it be a medical mask or similar to a surgical mask? Or then what types of masks then are acceptable? Would a paper bag with holes in it or a painter's mask be a mask? Then, next word, what does mandatory mean? Is this an objective test or a subjective test? An objective test means you have to wear one, even if wearing one would kill you. So there's an objective person out there that's not necessarily you in your particular situation. So you have to wear one, even if it would kill you or would prevent you from breathing because of some respiratory condition. Or you have to wear one even if you have a phobia of masks. If I wear one, I will have a panic attack and run into traffic. Or again, is mandatory subjective? It's only mandatory if I am physically or psychologically able to wear it without dying or going insane. And then, of course, what's the definition of insanity? Next, what buildings are we talking about? All buildings? Government buildings? Stores? My house? Also try obeying this law if you don't speak English. When I was a teenager on a trip to Germany, I was trying to push open a door to get into a gift shop. The door was jammed. I kept pushing. The door had German words written on it. I could not understand them. I didn't speak German. I still don't. A smiling German came up behind me, laughed, and said something. Well, it turns out the words on the door said, pull. So rule of law is at its most, or more basic level, rule of words, presupposing that words have meaning. I have to understand that meaning, and others in my jurisdiction, subject to that law or rule, also have to have the same understanding of what the word means. If we don't agree on what the words mean, we are going to have chaos, not a rule of anything. There would be no rule at all. One of those people who have to understand those rules, or one of those people who has to understand those rules is the judge, or the jury, or the judge and jury. There are lawsuits filed right now here in my jurisdiction. I live in British Columbia. Lawsuits that are hundreds of pages long, challenging the constitutionality of certain laws and mandates that have become quite popular around the world, around the West these days. I have heard the litigants in some of these cases say on social media, we have the experts. Our rights are clearly violated and we will win. Well, let me, if I may, give my estimate of their chances of winning in this environment on a 1 to 1% or 0 to 100% scale, or 1 to 10? It would be 0 on either scale. There's no chance of these lawsuits winning. I have one right here. Supreme Court of British Columbia filed, this action's filed August 17, 2021. If you want to look it up, it's Vancouver Registry, court file number VLCSS 217586. Action for Canada, Kimberly Woolman, the estate of Jacqueline Woolman, on and on. Those are the plaintiffs. The defendants are Her Majesty the Queen and Right of British Columbia, Prime Minister Justin Trudeau, Theresa Tam, Bonnie Henry, Adrian Dix, on and on and on. Okay? The lawsuit is incredible. Nearly 400, it's incredible. It's almost 400 pages long. Okay? And if you read this lawsuit, it's clear that there's an expression, throw everything at the wall and hope something sticks. And this would be one of those lawsuits. And if you read this, you're essentially getting a diary of what's gone on in the last couple of years from the other side's perspective. Let me just say that people who file these lawsuits are very naive. I don't blame them for doing it, and it's a good thing they do it. But we have to be realistic. To win, you are not only going to have to share an understanding of the words of the laws under which this permanent state of emergency is being governed, you're going to have to be able to share an understanding of the words with the defendants and the judge. And you're also going to have to have the same understanding of the facts. You say there is no emergency. You say these measures are unlawful or unjustified. Well, the government is going to say the opposite. You say it's bad policy, they say it's good policy. The government is going to have 10 experts for every one of your experts. These experts are going to say there is an emergency, and the response is reasonable. Maybe even the best response possible. The judge hearing your case is also going to have to agree on the words that apply, the laws that apply. For example, you say, the government has taken my freedoms under Section 2 of the Charter. That's the Canadian version of the Bill of Rights. Very different in structure, but it's the same idea. Section 2 of our Charter says everyone has the following fundamental freedoms: freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication, freedom of peaceful assembly, and freedom of association. Seems pretty clear. However, the judge is going to say, aha, I don't think Section 2 is the main issue here. I think Section 1 is the section that applies to your lawsuit. And let me read Section 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to reasonable limits prescribed by law, as can be demonstrably justified in a free and democratic society. Now that line, let's just talk about law here, the rule of words. Demonstrably justified in a free and democratic society. I'll suggest to you that that line, if you break it down, actually means nothing. It is entirely indeterminate. That means the words don't have any actual content. And you say that's impossible. I mean, you're going to say, well, at least we can agree what democracy is, can't we? Or what fairness is. Can we agree on that? No, we can't actually. Take the word democracy. Okay, does it mean direct democracy, Athenian democracy, where every citizen votes on almost everything? Does democracy mean representative democracy? You vote for someone to act on your behalf, but even then there's two theories, representative and imperative. One is your representative uses his or her best judgment, and the other one, he must obey the will of the constituency. So which one is it? That's if it's representative democracy. What about social democracy? Is that what democracy means? A government that pursues social justice? What about a society with a Bill of Rights? Is that a democracy? You elect a government that can't do certain things. Is it a democracy if it's a society that allows guns or bans guns? A society with racism or without racism? If you have a democracy but it allows slavery, is it a democracy? What if women can't vote? What if the unvaxxed people can't vote? Have you heard anyone say the election of a certain leader was undemocratic? They say that if 51% of the population votes for someone they don't like, it's undemocratic. We hear that all the time now. Or another one, I voted, but only 51% of the people in my riding picked the winner who is representing me. That's not democratic. I'm not represented. And these are the folks who think proportional representation would solve the problem. But again, what does democracy mean is my point here. If the 51% who elect the government persecute the 49% that didn't elect the government, isn't that a perfect democracy? Or is that undemocratic as well? What if the 51% white population put the 49% Japanese population in prison camps? Isn't that the will of the people? If a guy you think is dangerous is elected, like a certain German leader in the 1930s or 40s, does that make the election undemocratic? You didn't like the result. He's going to do things you don't like. He's going to put you in a camp, and you didn't vote for him. But of course, 51% voted for him, so isn't that democratic? So, as I said, the word democracy is in fact indeterminate. It doesn't actually mean anything unless you fill it with your political ideology, your morality. So isn't democracy just your idea of a good government? Is an Italian fascist state the true democracy because all segments of society are represented in it through this corporatist system that was part of that regime, and everyone shares in managing all levels of society, and workers share profits with the owners and have a say with how the companies run? Is that the essence of democracy, even though strikes are banned? So we have a problem. No one even knows what democracy is or means. And that is a hinge word in the limitation of rights under Section 1 of the Canadian Charter of Rights and Freedoms. In fact, what if we don't have the same values, the same morals? Is it possible for us to work together under the same Constitution? John Adams is quoted as saying, "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other." Then consider the sociological nihilism we live under. Everything is a social construct. There is no God, no higher morality. There's no natural law that human laws are not permitted to offend. Words have the meaning we give to them. An outcome determines what is just, not how you get there. What do you think the words you refer to are going to mean to a judge who is a sociological nihilist? When you tell a judge, my freedom of religion has been violated, but he doesn't like or she doesn't like the outcome of your argument. the words are probably not going to mean very much to that judge. And I ask you, isn't our government today more like one of the enlightened despots? More like Frederick the Great, who said, another quote, "The people say what they like, and then I do what I like." Isn't that the kind of government we have? Isn't that the mantra of the modern technocratic state that knows better and needs to teach you what to believe? And teach you what to think, actually. So getting back to the rule of law, I've digressed quite a bit there. The fiction is that words have content. They are determinative. And when a legislature makes a law, it can be understood by all. Do you really know what the law is? Do you really know the limits on government? Do we really know when we break the law or the government exceeds its power? Do we really only know when we're arrested and hear the verdict of the jury? And if you think of a number of show trials we've seen recently, did any of these defendants know the law until the verdict is rendered? Some of them may not know the law yet. What if laws of general application are only enforced if the law is broken by someone who's privileged, but not when it is broken by someone who's disadvantaged? Is that even a legal system? And I'm just going to quote for you from legal philosopher Lon Fuller, who set out 8 principles of what a legal system should have. According to Fuller, all purported legal rules must meet 8 minimal conditions in order to count as genuine laws. The rules must be 1. Sufficiently general. 2. Publicly promulgated. 3. Prospective, i.e. applicable only to future behavior, not past. 4. At least minimally clear and intelligible. 5. Free of contradictions. 6. Relatively constant, so that they don't continuously change from day to day. 7. Possible to obey, and 8. Administered in a way that does not wildly diverge from their obvious or apparent meaning. These are Fuller's principles of legality. Together, he argues, they guarantee that all law will embody certain moral standards of respect, fairness, and predictability that constitute important aspects of the rule of law. I mean, one can ask, then, how many of our legal rules are rules at all, if you consider these 8 factors. I mean, consider selective administration or lack of clarity alone, or laws that change from day to day. Our laws have become longer, more complex, more numerous. There's considerable delegation from the legislatures to the executive. This delegation is called regulations. There are more regulations than laws. Can anyone know what laws apply to them? Or are we not in many cases governed by contradictory laws? It was amusing and is amusing to watch the American scene with each side on the same facts accusing the other of breaching completely different laws, and in the end neither side is prosecuted, and we never really know who was right. But before we sink into despair, there are laws and courts, and there are laws and courts do make sensible decisions all the time, and there is a legal system. Everything isn't political. We see this mostly in the area of private law, relatively minor disputes between private citizens and or companies. This would also have been true under totalitarian regimes, where private disputes continued to be tried, most often with outcomes very similar across different legal systems and regimes. Where the government doesn't care, there is room for a rule of legality. In these situations, courts give life to the idea of the rule of law. they do make judgments. They hear evidence, they make findings, they come to reasonable conclusions. They tend to apply the laws using plain language and common sense analysis. This happens far more frequently than not. I'll give you an example. A makes a contract with B that he will deliver to B a cow in exchange for $100. This is a written contract and both A and B sign it. B pays the $100, but A refuses to deliver the cow. B sues A for specific performance, namely delivery of the cow, or in the alternative, return of his $100 plus interest on the money he hasn't been able to use since A took it. This is what we call a claim in contract. There's no dispute who the parties are. The cow is a biological entity. We can at least agree on that. And it's an entity that everyone in this particular country would recognize. You're not going to confuse it for a goat or a whale. And the monetary units in this society are standardized, so everyone knows what $100 is. Now, example 2. A fails to salt his walkway after a snowstorm. B is a visitor invited by A to his home. B slips, falls, and breaks his leg. This is a case of occupier's liability. The relationship between the parties isn't governed by a contract, but by a law, consistent with the principle of English law, which we've come to know as the neighbor principle. You could say, the second example, it's kind of like a debt arises. You unlawfully took my health and cost me a day of work. You now owe me compensation. There's we say in French, lien juridique, or a juridical tie between two people that didn't exist before the negligent act. So they didn't come to any agreement. There's no contract here, but there's a relationship arises from the negligence. Now here's the neighbor principle. A principle developed by Lord Atkin in the famous case of Donahue and Stevenson, which is also known as the snail in the bottle case, establishes when a duty of care might arise. The principle is that one must take reasonable care to avoid acts or omissions that could reasonably be foreseen as likely to injure one's neighbor. A neighbor was identified as someone who was so closely and directly affected by the act that one ought to have them in contemplation as being so affected when directing one's mind to the acts or omissions in question. You can see there's very definitely a moral underpinning to this. And one could say, you could say specifically in the European context, clearly a Christian underpinning, but not exclusively. In effect, people are expected to act reasonably and to have a duty of care, and they have a duty of care to look out for people who might be injured by their conduct. They don't have to be perfect, but they have to live up to the standard of care applicable in the circumstances. So A should have at least put some salt on the walkway. Now B falls because he stepped on the one tiny piece of walkway that wasn't salted. A isn't liable because he acted reasonably, the best he could. Now, that was just bad luck for B. It is literally just an accident. A met the standard of care. He put out the salt. Negligence is not a strict liability regime. It's not a strict liability game, although that isn't always obvious in court. So for there to be negligence, there must be a duty of care. The defendant must have failed to meet the standard of care. The fall must be caused by the failure. B didn't slip on his shoelace, for example. And there must be damages. If he's not hurt, that's it. You can't sue just because you're pissed off. Again, fairly simple, and much will depend on the facts, but these types of cases are decided all the time, and these types of rules do constitute rules of legality, and not without some discretion, not without variation. You can imagine a judge has a lot of flexibility interpreting the facts, in interpreting the standard of care applicable to a defendant in a particular case. How the law is interpreted will also be affected by the political climate of the times. In the 19th century, where freedom of contract was king, there are many judgments in which courts would say a deal is a deal. The most important principle in a laissez-faire economy is freedom of contract. The fact the boss has enormous economic power and you are a penniless worker does not matter. If you don't like the terms, go somewhere else. If that means you'd have to starve, it still means you have choice. And that also sounds a bit familiar, doesn't it, in terms of your freedom, in terms of your bodily integrity. If you don't like the rules, if you don't like the mandate, you can go someplace else. It's actually a throwback idea. We would say that is pretty close to mandatory, but not according to the current regime. As we get into the 20th century and the rise of Marxism, socialism, feminism, and things like critical race and critical legal studies, you are witness to new concepts introduced that account for power imbalances. For example, a court might say, yes, the contract was made, but it was unconscionable. There was unequal bargaining power, rendering the consent of the weaker party void. And here we start to see the notion that it wasn't really what it purported to be and should be set aside. You can find this type of language as well in any state consumer protection legislation. You also see concepts like giving ordinary people, if I can use that phrase, the right to change their minds. Now, Aristotle talked about two kinds of justice. First, there is corrective justice, which, if I can be brutally simplistic about it, corrective justice means moving rights between two people. My contract and tort negligence examples would be examples of corrective justice. There's been an imbalance created and you are going to correct it. Someone owes someone a cow, someone owes someone compensation for a broken leg, missed work, and you're going to correct that. Once you correct it, the balance is reestablished. Aristotle's other concept of justice is distributive justice, which dominates our world today. And you also see this reflected in words like equity, diversity, inclusiveness. These are distributive justice concepts. You're moving rights and assets around between parties that may never have met, they almost invariably did not meet, to correct purported social injustices. And this is for the sake of equity, inclusion, diversity. So you're correcting imbalances that are rather cosmic, as opposed to involving two people who know each other and had a lien juridique formed between them, either by contract or by negligence, for example, délit. In an ideal world, which we are not living in, corrective justice should be the purview of the courts, and distributive justice should be the purview of the government, of the legislatures. But where the rule of words starts to be a problem is when you get into the world of fundamental rights, which I've touched on already. Apart from purporting to enshrine fundamental rights, like Section 2 of the Charter, which I read to you, the other consequences of letting courts rule on human or fundamental rights is to invite the courts to enter into the world of the political. And this has given courts enormous discretionary power to in fact legislate for the good of society, as they see it. This was a huge incentive for a fully activist court. We see this fully developed in places like Canada. What happens then to the rule of law, or the rule of words, under an activist court? As I said, many people believe that courts find rights in this bill or that charter, If you want to know of marriage, what is marriage, you just look in the Bill of Rights or the Charter and it'll tell you what it is. Can marriage be between same-sex couples? And many people think, well, of course, because it's in the Bill of Rights, it's in the Charter. Well, no, actually. This is a matter of interpretation. And some would argue, and I would agree, is simply rewriting. Because we are brought back here to the question, what is the judge's definition of democracy? What is the judge's philosophy or morality? Or what social philosophy or morality does the judge feel compelled to obey? And one could make the same case in terms of abortion. Try finding a right to abortion in either a Bill of Rights or a charter written before modern, let's just say more recent times. It's not there. It has to be discovered, which is what the U.S. Supreme Court did. It discovered it within a invented right to privacy, which it read into the Bill of Rights. In Canada, there's actually never been an abortion decision. We have no abortion laws whatsoever. The previous abortion law was struck down for other reasons. Okay, we've talked about the political. What about the judging process itself? Are judges fair? I have been in front of a judge, and the issue was, could my client conduct surveillance on a plaintiff at any time, such as when he had a medical appointment with one of my experts? If the plaintiff has been hiding from the surveillance, picking him up at a specific place and time would be very useful to the defense. And of course, it is legal to conduct surveillance in public places. You can't sneak into their house and do surveillance there. Now, in this particular case, before I uttered a word, and before the judge had read my brief or heard anything from me, he looked down at me and said, "I hate surveillance." Now, was that going to be a fair hearing? What do you think the outcome was? Was the decision based on law, the rule of law, or words, or something else? I lost. Or in a jury trial, I'll give you another example. I was involved in this case. The plaintiff claimed he was permanently disabled from a shoulder injury and wanted millions of dollars from the jury. He said he was never going to be a power line technician because of this car accident and was going to lose millions. He wanted something like, I think, $2.5 million. I wanted to play that song by Glenn Campbell for the jury. He's a lineman for the county. I thought that would express how silly the plaintiff's argument was. I thought about it, and I did not play the song, of course. What I did decide to do is try to show the jury a clinical note made by his doctor shortly after the accident, in which the doctor wrote that the shoulder injury from the car accident had resolved, had gotten better. I thought that was relevant. The judge looked down at me and said, if I were the trier of fact, and by the way, in a judge and jury trial, the judge decides the law, the jury is the trier of the facts. So the judge looked down at me and said, if I were the trier of fact, mister, I wouldn't take any notice of that clinical record. I would ignore it. Clinical notes are, they're often inaccurate. I'm just going to ignore it. Fortunately, I thought to myself, the jury is the trier of fact here. And the judge knew that too, of course, and she eventually let me show the note to the jury. They would decide if they believed the note was accurate, if the note was an accurate reflection of the plaintiff's health or not. In the end, I put the note to the jury, and along with my other arguments, instead of $2.5 million, they gave him $35,000. The way the foreman smiled, it seemed seemed to her that they were doing him a favor. Now, why do I mention this? Judges have values. They have favorites. They may like claimants. They may distrust the defendant. They may like the private sector. They may prefer deferring to the government. They might hate lawyers retained by insurance companies and throw the book at the deep-pocket defendants. That is not about law. It is about the judge, or the members of the jury for that matter. We have a very activist Supreme Court in Canada, and I used to joke that you can often predict the outcome of the case by looking at the parties without knowing any of the facts. So what do words mean in a constitutional document? Very little, actually. Well, let's take an example from some of the examples I've given. Under the British North America Act, which is now known as the Constitution Act 1867, the powers of Parliament, which is to say the federal government, include, these are set out in Section 91, the legislative authority of the Parliament of Canada. It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada, in relation to all matters not coming within the classes of subjects by this act, assigned exclusively to the legislatures of the provinces, etc. I'll give you a few examples of powers that are exclusive to the federal government. Number 9, under Section 91. Beacons, buoys, that's B-U-O-Y-S, lighthouses, and Sable Island. And 26, marriage and divorce. That's all it says about lighthouses, and that's all it says about marriage. Now, at the time this came into force, marriage meant a marriage between a man and a woman. There was no other known meaning. That was the only known definition, so no one bothered to make that express. But of course, the Charter, as we know, talks about freedom and equality. It may well be that the society has changed, but the original constitutional documents have not changed. Would it be enough for a court to say a lighthouse is a cell phone or a hospital, to give the federal government power over cell phones and hospitals? No, of course not. But then how come marriage that has a fixed meaning can simply become something else? And that, in fact, has occurred around the West. The word marriage is simply in documents like this that are written before modern times. As I said, the Canadian Constitution division of powers was at least enshrined through Westminster in the UK in 1867, which is why we call it the Constitution Act 1867. It just says marriage. Shouldn't that have to be amended? Well, throughout the West, it has simply been reinterpreted to mean something completely different. That's an arguable point, and that's the problem with the rule of words. There are a lot of arguable points. It all depends on the temper of the times. In 2008, most people would have said a marriage is between a man and a woman. Of course, that's what I believe a politician would say. Today, no one would dare say that. But the words haven't changed. People have changed. So are you protected by constitutions? Sometimes, maybe. Things change because the rule of words and the rule of judges allows change. Same-sex marriage is legal in Canada, and the Constitution was never amended. People will tell you today this is obvious. That obviously marriage includes same-sex couples, but this is the public accepting what we call a very positivistic attitude. Positivism means if I make a law, it's moral, quite simply. And you see that, that's why I call it a positivistic attitude. People say, well, What are you talking about? It's legal. Well, just because it's legal doesn't mean it's right. They'll say, they'll go, what are you talking about? The Supreme Court says it's legal. Or the federal government says it's legal. Therefore, it's legal. And I'm just saying that's a positivistic attitude. They're not recognizing that a law can be wrong. A judicial decision can be wrong. Although in other contexts they will. So let's call it selective positivism. We see here is that many people in our society still believe in the rule of law in every context and fail entirely to see that it is often writ in sand. It's indeterminate. It is majoritarian and favors interests friendly to the regime. If you're in the minority and your interests are not friendly to the regime, you cannot rely on the rule of law. There is a reason riots occur over unpopular decisions. The majority understands there's only one possible decision, the political one. And when they don't get it, they riot or induce the riot. And then what happens when the rule of law, the rule of legality, is corrupted? Which is to say, no one believes in it anymore. What happens when no one expects a fair hearing? In those circumstances, we move to a very different kind of society. We may already be there. One in which the very idea of the rule of law or the rule of legality is forgotten.